This jury took their involuntary assignment very seriously. They obeyed the instructions of the court. They obeyed their oath. These good and decent citizens of Colleton County stood to their duty and rendered their verdict without fear or favor. It was a difficult task. 11 of the jurors very unconditionally said they either heard no comment, or if they heard a comment, it had no effect. One juror was ambivalent in her testimony. She was then examined on her previous affidavit, in which she said the effect, if any, that she had was pressure she felt from other jurors. The cases are myriad that pressure from fellow jurors is a part of the normal give and take of jury deliberations. The court is not to inquire in any way about what is said in those deliberations. But the juror, who was somewhat ambivalent, said on her oath at the time of trial twice, and said on her oath before me in these proceedings, that she stood to her oath. The clerk of court allowed public attention of the moment to overcome her duty. I have read the entire transcript of this lengthy trial, not an easy task. I have studied in detail all of the authorities cited. I have independently researched the case law, learned treatises, and scholarly articles on the subject. Although there is certainly a split in the federal circuits and in the states on the standard of review, I simply do not believe that the authority of our South Carolina Supreme Court requires a new trial in a very lengthy trial such as this on the strength of some fleeting and foolish comments by a publicity-influenced clerk of court. This is a matter within the discretion of the trial judge, and I am the trial judge at this moment. I do not feel that I abuse my discretion when I find the defendant's motion for a new trial on the factual record before me must be denied